welcome back to another U.S. immigration law video. The purpose of this video today is to clarify some misconceptions that are both out there in the media and politically that are inflaming the relationship between the United States and Canada, and that are distorting the immigration process, making it seem like things are much more severe than they are in reality. And the media is circulating a few stories that they just keep putting through the ringer over and over and over and over. And you've probably heard them multiple times if you're paying attention at all to the media when it comes to immigration in the United States. And that's the cases of Jasmine, Mooney, and Rebecca Burke. And one thing that I will caution is be careful where you get your information. Be careful what news agencies and outlets that you are listening to, and fact check, and fact check. A lot of these individuals are inflaming the situation. They're using two very limited examples, and we're talking about exceptions to the rule. This is not normal. These cases do not happen on a regular basis. And if you pay attention, how many cases are they throwing out there? Well, two, and one of them was not even a Canadian. Only one of them was a Canadian. And there are thousands of Canadians that commute to the United States daily that do not face these issues. And I think everybody will agree that the situation that these individuals went through was very unfortunate, that it was probably excessive on how they were treated. But we can learn from what happened in those situations so that you can prevent any issues that may occur with you when you're traveling back and forth to the United States for whatever purpose, whether it's for vacation or business, whatever brings you to the United States. What I want to clarify in this video is that process is the same process as you have went through before. Now, you do need to take caution. You do need to be aware of the current political climate, because politics has always played a part in immigration. Every 4 years in U.S. immigration, there's a new president. And under that president, they have their agenda. Now, the laws, for the most part, don't change, but how they choose to enforce those laws do. And that's what we're seeing. We're seeing a swing in political agenda under Trump 2.0. And it's very similar to how he did things the first time he was president. The difference here is they're getting out there in the media, they're publicizing it, they're up there with their bullhorns, making sure everybody is aware that they are enforcing immigration laws for violators. And that's what's important to understand, for violators, not for those that are following the rules. So let's go back to the cases of Jasmine, Mooney, and Rebecca Burke. So Jasmine Mooney, we could talk about this case all day. But Jasmine Mooney faced multiple different issues with her entry to the United States and working in the United States that led to her detention. And one of the funny things about Jasmine Mooney is her issues started under the Biden administration. She was ultimately given her last and final warning and removed because she kept insisting and applying to get a visa in the United States when she was told that she did not qualify, that what she was doing was not acceptable. She had 2 visas revoked and wouldn't give up and kept applying through different methods. And ultimately, CBP said, yeah, enough with this. You are not coming to the United States. And in the end, she was actually given a fraud finding, a misrepresentation finding that led to her detention and removal and being sent back to Canada. So she's an extreme example. Most individuals are not going to find themselves in a situation where they have their visa revoked 2 times and that they try to apply by mail with USCIS, they try to apply through Canada, then they ultimately go to Mexico, all trying to circumvent the US immigration system, thinking they're not going to get caught in what they're doing. That, in essence, is what Jasmine Mooney was doing. She was trying to find a loophole, get through the system, and try to do something they had told her she was not able to get a visa for. And ultimately, they removed her from the United States. And we're going to discuss how that could have gone better for her. In my opinion, there was some very bad legal advice that she was given in the way she went about doing things. And she didn't take her previous refusals And revocations of visas, seriously. And if you have an immigration history, if you have violations, if you've been revoked a visa or denied a visa, take that seriously, because it does have it's on your permanent record, and it can complicate future visa applications or entries to the United States. So her case is rather extreme. We don't see that very often. And part of it stemmed from bad advice that she received. So make sure that when you are coming to the United States, that you are receiving proper advice on your situation and that you're applying for the proper status. And if you've had previous violations, make sure you address those properly so you don't get put in that type of situation. Again, case in point, extreme. This is not the norm. This is not what typically happens to any traveler, let alone Canadians to the United States. But if you put yourself in that situation, if you put yourself in a situation where you're going to give them the opportunity to ban you from entering the United States or to revoke your visa, of course they're going to do that. The other case was Rebecca Burke. Rebecca Burke was traveling throughout the United States and she was documenting her travels. But when she was doing this on a visitor visa to the United States. A visitor visa does not allow you to productively work in the United States. There are some exceptions, but in this case, what happened is Rebecca Burke was traveling to the United States. She was working for her foreign employer, and she attempted to enter Canada, and Canada found out what she was doing and said, hey, you need a work visa. You can't be doing what you're doing without a work visa. And Canada turned her around and sent her back to the United States. Well, when you get turned around from Canada back to the United States, CBSA does so with a note saying, hey, CBP, we're turning her around for these reasons. Well, they told CBP, hey, this lady is trying to work in Canada without authorization. We can't admit her unless she has a proper work visa. What do you think CBP is going to do at that point? Well, they looked in the situation and they're like, oh yeah, well, guess what? You need a work visa to do that in the United States as well. So she was put into that situation because she was doing something she was unauthorized to do on her visit to the United States. She did not have a proper work visa. So in both situations, these individuals were not complying by their visa status. They were not doing things that they were authorized to do with the visa that they were in the United States on, or they violated that status and the visa was revoked. So make sure you understand the limits of your visa. Make sure you're obtaining the proper visa to do what you're doing in the United States. This has always been the case. This is not anything new. If you come to the United States, you are coming so under as a visitor, as a worker, as an immigrant, as a non-immigrant, and you need to understand the limitations of what you can do in the United States if you are a non-citizen. So in the end, why are Canadians facing more scrutiny, or why does it feel like there's more scrutiny? Well, number one, these stories are circulating in the media, making it seem like this is happening to every Canadian. No, it's not. Again, this is the exception. We have not yet had one client go through anything remotely similar to what these individuals have done. Our clients go properly prepared, and because of that, they're coming to the United States under the proper visa status, and they avoid these situations because they're doing so above the law. Now, a lot of this comes from the executive orders from Donald Trump and increased scrutiny. Well, he did increase scrutiny under his first presidency. This is not new. Again, he was president for 4 years before, and he is following the same game plan as he did before. He's just doing it louder, and he's doing it, frankly, because he's a lame duck president, and what does he have to lose? It's not like he's going to run for election again, so he doesn't really care about the consequences or what people think, and he never has. And you're seeing that as far as the scrutiny. It's increased. If you're going to give CBP the opportunity to revoke a visa or deny it, well, they're going to do it. They feel empowered to do so, and they have a lot of discretion. They've always had a lot of discretion. And right now, they feel very empowered to use that discretion against individuals who are, again, violating their status in the United States. So when you're coming to the United States, one thing that is important to understand is how you're entering the United States, because it does matter. You can enter the United States typically on an airplane, or you can enter the United States through land inspection. Now, when you're coming to the United States through what is called pre-flight inspection or pre-clearance, that means CBP is conducting your interview in Canada on Canadian soil, and they're doing so under the authorization of Canadian law. Because of that, they have limited powers of detention, and they have more oversight from the Canadian government, and they can't detain you because you are on Canadian soil. They can refuse you, they can revoke a visa, and they can tell you never to come back to the United States. But because you are on Canadian soil, you have protections of the Canadian government and Canadian laws, and you're not going to be put into the similar situation when you find yourself in removal proceedings because you're not in the United States yet. You are seeking permission to go to the United States while remaining on Canadian soil. And pre-clearance is available at most major Canadian airports like Toronto Pearson, Vancouver, Montreal Trudeau, Calgary, Ottawa, Edmonton, Winnipeg, Halifax. These are pre-clearance airports. There are some that are not. Billy Bishop, Toronto Island Airport is not pre-clearance. If you fly through there, you're being inspected when you land in the United States, and then you would be inspected on U.S. soil. So there are advantages to pre and clearance, and you have more protections as a Canadian. Now, I'm saying this because that's the reality. It's always been the case. I'm not doing it to scare you or to make you think like you should always fly to the United States, because that's not the reality. The reality is if you're coming for a legal purpose to the United States, you should feel free to fly or drive to the United States. But if you are flying, it does offer you some more protections when it comes to the law. Now, if you're driving to the United States, and both Mooney and Burke were doing it this way, they were both doing the land port. Remember, when you are coming into the United States, you are on U.S. soil when you're speaking to CBP, when you're doing a land port. You are already in the United States. You have left Canada, and you are being inspected on U.S. soil. So at that point, CBP has a lot more discretion in what they can do. And CBP at that point could detain you if they are justified in doing so. Most of the time, again, it's only going to happen you're to be detained if you have committed some violation, either immigration or if you have committed a criminal act. Now, why were both Jasmine Mooney and Rebecca Burke detained? Well, think about their situation. Rebecca Burke was a citizen of the UK. She wasn't a citizen of Canada, and she wasn't a citizen of the United States. So when she was refused, the United States couldn't send her to Canada because Canada had already said, hey, we don't want her. She's coming here to work. And she wasn't a U.S. citizen, so they couldn't release her into the United States either until they clear her to be released. So she was put into a holding center because she was not a citizen of either country. So unfortunately, she put herself in that situation through violation of her visa. Jasmine Mooney did the same thing. She tried through Canada, and if you follow her record, well, the United States will give you the opportunity to go back to Canada without being put into removal proceedings. They could give you what's called voluntary departure, where you say, yeah, I can see it, I'm just going to go back to Canada. I don't want to fight this. Or you could go before an immigration judge in the United States. Well, Jasmine wasn't applying through Canada. She was applying through Mexico. And when she did that, she gave up those rights. She was applying as a non-citizen of Mexico into the United States, where she was also not a citizen. So when she was refused, they found the finding of fraud. They couldn't just release her back to Mexico. She wasn't a Mexican citizen. They had to remove her to Canada. And that's unfortunately led to her detention. Now, again, their situations were extreme and unfortunate. How long they were detained was very excessive. I think we can all agree. But because of how they did this process, that's what led to their situation. Now, when you're coming to the United States, understand the CBP has broad discretion. They can search your electronic devices, your phone, your computer. They can search your person, your belongings. They have always had this discretion. This isn't something new. They've always been able to search your phone. They've always been able to search your laptop. Now, do they? Well, 99% of the time, no, they do not. We've had very limited situations when a client has had a device search. CBP isn't just going around searching people's devices. They need to be justified in doing so and have a reason to search your device. They don't have the time just to search everyone's device, and just the thought of them doing that is just absurd. That is not happening. It has never happened. Now, they do have the discretion when warranted to do so, and they always have. And anybody advising to get a burner phone or wipe your devices, that's bad legal advice. What are you doing? Are you a criminal? What are you trying to hide? That could cause you more problems than good if you're doing something like that. We would never advise you to lie or to hide information from the US or the Canadian government or from anyone for that matter. If you are doing the process legally, you are following the laws, you have nothing to hide. So why would you have a burner phone? And why would you care if they search your device? Sure, you might have personal information. CBP doesn't care. They want to make sure that you're not violating the law. If they're searching your device, they are looking to see, hey, you're coming as a visitor. We don't think you're coming as a visitor. We think you're coming to work. So then they're going to search your device to see if you are in fact coming to work. Valid reason. Or you say you're coming as a visitor, but in reality, you're coming here to obtain a green card and you don't plan on returning to Canada. Well, if they don't believe your story, they can search your device to verify. So these are legitimate reasons to search your device if they suspect that you're doing something, again, that you're not authorized to do during that visit to the United States. Going back to what I've said throughout this entire video, they're verifying your intent is what you say it is, making sure that you're not lying. And that's one of the worst things you can do with immigration and in life is to lie, to commit fraud, or to misrepresent what you're actually doing. Now, these cases are extreme. They are not the norm. If you're coming to the United States as a Canadian, do so as you normally have. Do it legally, do it properly, do it with the proper intent. The one thing that has changed is the alien registration requirement. That is only for Canadians staying over 30 days. Most Canadians staying over 30 days are doing so on a green card or a work visa and have already met that registration requirement. Well, if you're a snowbird or you're driving into the United States and you are staying over 30 days and you did not meet that registration requirement, well, go online, do the form G325R and register. It's not that big of a deal. And in reality, it's a very small thing to do if you're staying in the United States for up to 6 months. That's a long time without the need of a visa. So Canadians still benefit. They still are able to come to the United States for 6 months at a time without having to obtain a visa to do so. And that G325R is a simple requirement to register yourself in the United States. Hopefully, this discussion clarified these cases, clarified what happened to these individuals, and clarified that for the majority of Canadians coming to the United States and doing so legally, that have legitimate work purpose or purpose to visit, have the right visa status, have nothing to worry. Do the process legally, follow the rules, don't lie, obtain the proper visa status, and you should have no problem as a Canadian coming to the United States. You should not fear. Any questions about U.S. immigration? We help Canadians come daily to the United States to work and to live. We have not experienced these same issues. Again, these are the exception. They are not a normal situation when it comes to U.S. immigration. Any questions that you have, please reach out so that we can clarify your situation and so that you can understand the proper visa status that you need to come to the United States to do what you need to do here in the United States. Thank you for watching and have a great day.